In this video presentation, we are going to see the meaning of permissible and impermissible delegation. The function of making of laws is of legislatives, but due to the sake of need and necessity, this function is delegated by the legislatives to the executives, and the functions which may be delegated by the legislatives to executives within the limits without violating of the Constitution is known as the permissible delegation. Let us see some examples of permissible delegation. First, permissible delegation is commencement of a statute. An act may provide that it would come into force on the appointed day, that is, on the day decided by the executives. Here, executives can be the central government or state government. In such cases, the operation of the act depends on the decision of the government. We can take example of the Consumers Protection Act 2019. In section 1 subsection 3 of this act, it is provided that the act shall come into force on such a date as the central government may by notification appoint. One interesting comment given by the famous English administrative lawyer Sir Cecil Carr as the legislature provides the gun and prescribes the target but leaves to the executives the task of pressing the trigger. In the landmark case Queen vs. Burra, the delegated power to bring the law into force was upheld. Next, permissible delegation is supplying the details. If the legislative policy is formulated by the legislature, the function of supplying the details may be delegated to the executives for giving effect of this policy. This is the most general form of the delegation, and it is found in several statutes. In all such cases, a legislation enacted by the legislature is skeleton legislation, and the legislature lays down the general principles in the statute. Section 3 of All India Services Act 1951 authorizes the central government to make rules to regulate the recruitments and the conditions of services in the All India services. The next permissible delegation is suspension. The act passed by the legislature, for example Parliament, may authorize the executives, for example government, to suspend or relax the provisions contained therein under certain circumstances. For example, under Section 48 of the Tea Act 1953, the central government is empowered under certain circumstances to suspend or relax the operation of all or any of the provision of the said act. Sometimes provision is made in the statute authorizing the executive to modify the existing statute before application. This is termed as modification, and this is really a drastic power as it amounts to the amendment of the act, which is basically a legislative function. Hence, it must be delegated if there is need and necessity. By considering the future danger or risk of misuse of the power by the executives, it is therefore utmost important that the legislature must formulate the policy in clear and unambiguous terms before the delegation of such power. Example of such modification is Delhi Laws Act 1912. Under the power conferred by the Delhi Laws Act 1912, the central government extended the application of the Bombay Agricultural Debtors Relief Act 1947 to Delhi. The Bombay Act was limited in application to the agriculturalist whose annual income was less than 500 rupees, but the limitation was removed by the government in the Delhi Act. Here, it is important to note the proportion laid down in Re Delhi Laws Act that the legislature cannot delegate its power to repeal a law or even to modify it in essential feature. Thus, each law or enactment has its basic structure or basic feature which cannot be modified by delegated legislation. Also, it was held in Hamdard Davakhana vs. Union of India that the legislature cannot delegate the uncanalized and uncontrolled power. Next delegation is of prescribing punishments. In some cases, the legislature delegates to the executives the power to take punitive action. For example, under Section 3 of the Electricity Act 1910, the Electricity Board is empowered to prescribe punishment for the breach of provisions of the Act subject to maximum punishment laid down in the Act. This practice is not objectionable provided the two safeguards must be adopted. First is the legislature must determine the maximum punishment, and as per second, if such power is delegated to any authority other than the state or central government, the exercise of the power must be subject to the previous sanction or subsequent approval of the state or central government. Next is the delegation of power of removal of difficulties, which is also known as Henry VIII Clause. As legislature cannot foresee the future difficulties in implementation of the Act, executives are empowered to make the necessary changes to remove such difficulties. This clause is located across number of the statutes in India, even in Article 392 of the Indian Constitution. Power to remove difficulties is given to the central government in Section 298 of the Income Tax Act 1961. Removal of doubt or difficulty clause is also known as Henry VIII Clause. In several legal commentaries, two types of the Henry VIII Clause have been identified, narrow and broad. The narrow Henry VIII Clause permits the executives to enact delegated legislation which does not contravene or derogate from the provisions of the Parent Act. Broad Henry VIII Clause permits to do so, and in no doubt the Indian judiciary has unambiguously accepted the narrow Henry VIII Clause. The functions which may not be delegated by the legislature to the executives are termed as impermissible delegation. In Re Delhi Laws Act, which is known as the Bible of the delegated legislations, it was held that essential legislative function cannot be delegated. The essential legislative functions consist of the determination of the legislative policy and formally enacting that policy into a binding rule of conduct. Thus, while studying impermissible delegation, we have to always keep in mind that essential legislative functions cannot be delegated. Now, let us see one by one which are the essential legislative functions. To lay down the policy, intent, purposes, to declare penal laws and punishments, to impose tax, to decide jurisdiction and power of tribunals, to give retrospective effect to an act. These are some of the essential legislative functions. With regard to the delegation in taxing legislation, it is important to note that the power to impose tax is essentially a legislative function. Under the Article 265 of the Constitution, no tax can be levied or collected except by the authority of law, and here the law means the law enacted by the legislature and not made by the executive. Therefore, legislature cannot delegate the essential legislative function of the imposing tax to the executive authority. Subject to this limitation, a power can be conferred on the government to exempt a particular commodity from the levy of tax. A power may also be delegated to bring certain commodity under the levy of tax. Before concluding our discussion, let us see the proportion held in Gwalior Rayon Silk Manufacturing versus Assistant Commissioner of Sales Tax. Accordingly, delegation is valid only when the legislative policy and guidelines to implement it are adequately laid down, and the delegate is only empowered to carry out the policy within the guidelines laid down by the legislature. At last, we may conclude that the legislature must retain in its own hand the essential legislative function. Once the legislation lays down the policy, it can delegate it to the executive authority. This delegated legislation is the ancillary or subordinate legislation which is necessary for carrying out the policy and purposes of the Act. These are necessary to make the legislation effective, useful, and complete. The delegated legislation must be consistent with the Parent Act and cannot travel beyond the legislative policy and standard laid down by the legislation. Several safeguards against the abuse of delegations must be retained by the Parent Act to make delegation valid, otherwise it may be excessive, impermissible, or unwarranted.